Yeah. Okay. Good morning and welcome. Now, the judiciary has been in the public domain. Discussions of its reform have occupied the public and the media for the last several years. And despite the reforms, of course, there are still complaints about the performance of the judiciary and the delivery of justice in this country. And this week, the judiciary meets the top, as they call the superior courts. Judges of the superior courts are meeting to look at various issues. And we are favored this morning to have the principal judge of the High Court, Justice Richard Mongo, accompanied by the director of the Judiciary Training Institute, Justice Professor Joel Ngugi. Karibuni.
Thank you.
Well, first, this week seems to be the judges have taken leave from work. So there's no justice going on or what? Yes, Justice Mongo, let's start with you. Courts are not functioning or they're working at a certain level.
Under the law, under the Judicature Act, there is a provision that requires or allows judges thrice in a year to go on a recess. When that recess occurs, three times in a year, the courts, the high courts and the superior courts close. Except that, of course, there are duty judges to handle urgent certificates of urgency, and those are dealt with by a duty judge. The main reason why this recess is necessary for judges is because we judges have lots of cases that we have to carry over, and therefore we need time during the recess to write these judgments. It's very important for us. If I just give you very briefly, just so that the public understands, because I've had to explain this many times to individual persons. A judge's life on a daily basis is something like this. You start in the morning at 8 o'clock by looking at the number of files you have in your cause list. The physical files are then on your table, and you flip through them to see what you're going to do with them. Some are for mention, some are for hearing, some are applications, and so on. So you do that, and it may take about an hour or so to go through the cause list. Then you begin to hear the applications. The applications may take you up to about lunch break. Then you may need to do hearings of matters that are either part heard or matters that are fresh for hearing. That may take you into the afternoon. If you say that of the applications you deal with, 2 actually proceed, it means you have 2 rulings that you carry home with you. If the hearing completes, it means that you carry the hearing, the file with you. So if on a daily basis, a judge, and this is very conservative, if a judge carries 3 matters every day home to work on, it means that in a week you have 3 times 7, 21 matters to write. That's conservative. So you need, and then it builds up over the month. If you have about 50 matters in a month, you are in trouble.
Yeah.
Because then it means that either you're working most of your time at night and on Saturdays and Sundays, which means at some stage you need a bit of breathing space to actually write those rulings and judgments.
So this break, the judges use to prepare those judgments.
It is the best time in life because there's no disturbance and you're not on the
How long does that period last? How long is the period?
In August it is 4 weeks, 5 weeks actually. The other in April, and in December it is shorter upcountry. In Mombasa, the long period is during December. That's when they have their 6 weeks.
All right. Now, okay, let's come to this week's, this program that you have is very heavy with a lot of presentations. You're terming it Judicial Review in Transformative Constitutions, the case of Kenya. What is the focus really? What is it, Judiciary Training Institute is the one that has convened, organized this. Tell us about it.
Okay, thank you. So the main focus of the conference, as the title suggests, is on to give the judges an opportunity to consider the implications of Constitution of Kenya 2010, about 4 years into its implementation and interpretation. We are very deliberately calling it a transformative constitution because that is what Kenyans intended. And we will spend a little bit of time with the help of other comparativists from other countries and Kenyans who will come and make presentations to really look at the power of judicial review, or constitutional review as we call it in Kenya, that is that has been given to the judiciary in the Constitution, and the different theories of interpreting the Constitution. So that's really the main focus. But we'll spend a little bit of time also discussing some of the emerging areas of jurisprudence, including our electoral jurisprudence. And then a little bit of time will be spent to talk about some of the judicial policies that affect us as judges.
In the final analysis, what do you want to achieve?
Like it's a judicial conference. So just like in academia, you need every so often to get really the intellectual leaders of the judiciary together, retool them, equip them with new theories on, and also the emerging jurisprudence on how to interpret especially the Constitution, but this also trickles down to other areas as well. Afford them the learning that is coming from, you know, even outside Kenya. That's why we have comparativists here, and just get them to really embrace the culture of learning. One of the transformations that we've undergone in the judiciary is one of trying to transform ourselves into a learning organization where learning is taken seriously, where intellectual poise is encouraged in everything that we do.
That sounds to me like appropriate time, because we've been getting the judiciary issuing diverse rulings. In the election cases, petitions for instance, eyebrows have been raised about consistency from the bench. Well, each of the levels, of course, have their own take on an issue. But you have a petition, you know, somebody, election revoked by the High Court. The Court of Appeal reinstates, Supreme Court goes back to the High Court position. And all this process taking a lot of time, and people are saying, "Hey, what is going on?" They, you know, Court of Appeal making decisions, Supreme Court overruling them, or going back to the High Court decision. Are you going to use this opportunity to try and harmonize, or, you know, get some intellectual inbreeding about really what what ought to be the judiciary's posture?
That's the first time I've heard the word inbreeding used positively.
Yeah. It's raising issues, I'm sure. And you must also be getting concerned. Actually, the vibe out there is that the Court of Appeal is very unhappy with the Supreme Court, or, you know, there are people saying things out here about the fact that a series of judgments have issued that seem to completely reverse what people thought would be the case here.
Yeah. I think, well, in the conference we will have a session. I think it's
Wednesday.
On Wednesday.
Yes.
Where we will have a panel of judges discussing the question of emerging jurisprudence from the election period in relation to electoral law. Now, different judges will be speaking perhaps from different perspectives about the effect of the electoral process and the jurisprudence in their courts. So we will have somebody from the High Court, we will have somebody from, I think in fact 2 each, from the High Court and the Court of Appeal and the Supreme Court will hopefully be there. So the idea is for us to discuss what it is that we did. Now, of course, the decisions have already been read by those, by the various courts. And it is the prerogative of courts or of a judge in his judicial independence to determine, or for a panel of judges to determine what is their understanding of that electoral law and the process that was used. So that will be the discussion that will be taking place. I do not consider that we will be trying to harmonize, because judicial independence is about even judges in a panel agreeing or disagreeing, and when they disagree, they issue a dissent or a dissenting opinion. When they agree, of course, then it becomes part of the majority decision. So I do not expect that we will be harmonizing, but we will be clarifying for ourselves what is it that one group that heard the actual parties, what is it that they understood? And the group that did not, the Court of Appeal, that did not hear the parties, what is it that they understood from the decision? The third group would be, of course, the Supreme Court. What did they, not also having heard the parties, what did they understand was going on in the two courts?
Yes. And of course, one of the things that we'll need also food for thought is people thought that after elections and setting the period of 6 months within which all those issues need to be adjudicated should have been the limit, so that we don't have cases dragging in the courts going like you happened the time before, where a whole election term is served while somebody's election is contested. But we have seen it stretch to the Court of Appeal and then up to the Supreme Court, which people did not think was anticipated or intended by the Constitution.
Is an appeal court.
Yeah. But now every matter is going up to the Supreme Court. Secondly, the time during which the petitions need to be dispensed with has become tenuous, not the 6 months anymore. I guess that would also be an issue that needs some.
It will be discussed because I think the Supreme Court takes the view that the Constitution, I think it's Article 163 or 162, has a provision that allows the jurisdiction to deal with constitutional issues at a certain level. Now, if the case that is brought before it raises some constitutional issues, I think the Supreme Court will entertain that kind of jurisdiction. That's what they have
that's
said.
what has been happening.
Now, don't be very unkind with the judiciary at this point, David Makali, because we are in August.
Yes.
And we have already had 2 levels of hearings. That is the High Court and the Court of Appeal. And I think those that are now in the Supreme Court are in the process of completion. So we are still doing very well. It's barely a year and a few months since the election was held. In the old days, of course, you will recall that the High Court alone would take 5 or 6 years, perhaps, before the completion of its own hearing, leave alone the appeal.
Yeah, it's true.
May I know whether
your
conference is being covered by the press?
No, our conference really takes more of the form of a family meeting.
So, we are interested in what is being discussed there.
No, so we will.
The public is interested.
So
what is being discussed there?
We will share with, and we are here, in part to report what we plan to discuss, and we will issue daily press releases on what was discussed. But really, I think judges sometimes need a space where they can have honest conversations which are not being recorded by the media and so forth. And this is afforded to all the judges of the Superior Court only once in a year. And it's only in a place like that when we can talk about some of the issues that you're talking about. I hope you appreciate that sometimes you need all the judges of the 3 levels to actually sit down and
have internal quarrels.
And just have an internal conversation about it. But importantly, let me just say something for Kenyans, because I've had the anxiety, and I understand the anxiety that Kenyans have about the seeming overturning of cases and so forth. First of all, I think Kenyans need to understand that that's exactly what our system envisaged and intended, and for a good reason. The idea is to keep clarifying the issues until you get to the highest court, which then issues the jurisprudential direction. Because according to the Constitution, the decisions of the Supreme Court, they bind everyone else. Okay, so once it gets to the Supreme Court, they issue the decisions and so forth. However, at the same time, it's important that we have this kind of intellectual conversations with the judges of the Supreme Court, because we might be able to persuade them, for example, that their reasoning, could be improved and so forth, and then they might be able to overrule themselves. It's only the Supreme Court that can overrule itself. Can revise their earlier position. So I would ask Kenyans, our Constitution is still very, very young. It's 4 years. and there are a lot of things that are being clarified, and they're only clarified through lawmaking because we are a common law system. So these cases have to make their way through courts, and then a position is reached, and it's going to be much, much easier in the next election cycle. This is the only election cycle we've had under the new constitution with a new set of electoral laws and so forth. And even then, the High Court finished all the cases within the 6 months that are constitutionally provided. The Act of Parliament extended that period by 6 months to the Court of Appeal. And then now a lot of these cases we are seeing will now set the jurisprudential path for the electoral decisions, which will now be applied in the next elections, which we hope and expect will be much smoother.
Definitely, there are still challenges. People, and by the way, if you're watching this, you're a lawyer, you're a consumer of justice, you can be part of this conversation. You can send in your questions to the two judges, 22422. They have just about 15 minutes. We might get opportunity to ask your question directly to the judiciary. The question has been raised, and in fact, from legal circles, lawyers themselves, that there are still disappearing files, which we thought was now extinct.
The chairman of
phenomenon.
the Law Society of Kenya, Mutua, was here, sitting on this seat, said their own files have missed.
Even their own file in the dispute they have over with the Attorney General or something disappeared. I mean, there still are challenges. Would you say so?
Yes, let me speak to that as the head of Judicial Transformation Secretariat.
Yes.
It will be monumentally dishonest to say that we don't have challenges. We do still have a lot of challenges, and but it's not surprising. These are things that we expected. We didn't expect that we were going to transform this institution that has been in existence, since 1897, in a year or in a few months. We knew that we were going to get a lot of challenges. But I think it's important as Kenyans also to celebrate some of the successes that we are having in our institutions. And the phenomenon of missing files has improved so dramatically in our courts, especially for just the average consumer of justice, very, very dramatically. And we've put in place a lot of mechanisms through which one can complain, raise issues about missing files, and so forth, including the Office of the Ombudspersons and so forth. Now, on average, now it takes 6 minutes to retrieve a file from our court registry, and as a lawyer, I would encourage you to actually go and try with, and ask to peruse a file, and you will find that this is generally true. Of course, there are few cases that are still there of files that are missing. Some of them are missing because our records over time have been very, very bad, and some of them are just physically not there. We've had cases, like when I was in Machakos, you're aware of this, of cases that were, physically consumed by ants and rodents. So you can't find those. Those are actually missing in reality, and they have to be constructed.
Gone forever.
They're gone. Then of course, it's true that we have the odd case, like the one that you mentioned. I do not know specifically about that case, but of course, you'll get one of those, once in a while, one of those cases. But I would like us, I think sometimes we proceed from what I call the Volvo fallacy. The immediacy of something that has happened distorts our view of
the bigger picture of things.
Yes.
Yeah.
And let me say, David, that I was never aware of the complaint of that missing file. It may have been made maybe to the ombudsman, but if it was a file which was in the High Court, I should have been made aware.
Right.
Because it is very easy to find a file when I am looking for it. I just need to issue an instruction,
yes,
and normally I will be told where the file is.
Yes, of course, if the matter is brought to your attention,
yes,
but will not normally happen. That will not normally happen because litigants will come to court. A lot of things happen behind there, and I've even had people come to me to complain about how matters never progress. So along the way in the judicial process, there are still cobwebs and bottlenecks that need to be overcome in accessing justice. Either matters not being listed quickly. Maybe we'll talk about that because there are people who say they still live in the courts for so long to get their matters adjudicated. What is the standard if we were to use the global phenomenon now of international certification, ISO,
Yes.
what is the standard procedure for obtaining justice in Kenya?
Let me say one of the things that we have done. Other than physical space, providing physical space in terms of cabinets and bulk filers and so on, one of the things that we have recently launched is the Registry Operations Manual. And that is a document that documents, you will be surprised, gentlemen, that in the past there was never a system that documented a process from the date when a file is opened to the date when the file is disposed of. There was no document.
Yes.
So we have always gone on the basis that the person who knows best in the registry what happened is the person we need to find to help us with the process. Of course, different clerks have had different levels of knowledge and information. And so it became easy in the past to identify certain people who could help you either with a file or who could help you lose the file or make it disappear. Because the person with knowledge has certain types of power. Now, we have now documented the system. And it is going, it has been validated at 1 or 2 levels. We are still working on its validation, and we are now doing a pilot to see whether that system that we have documented is applicable across the board, in all courts across the board. So this is one of the things that we'll be doing in the next season, starting the next term and into next year.
But let me ask you, Justice Mwongo, before I will come to you about some matters which are very pressing. Still, there are people who go to court, cases are filed, they'll take 3 years, they're still within the High Court. And there are those who come before that High Court, and within 1 month we've had decisions made on them. What is it? Especially political nature cases, and these things are being processed quickly. And somebody says, don't I go to the same High Court? How come my matter hasn't been determined 3 years down the line?
First of all, you must remember that there are different types of cases. Cases that are brought under certificate will normally be speeded up.
Yes.
Because there is some urgency which the judge, in the certificate, it would normally be explained in the affidavit that accompanies the certificate. Why is there urgency? Maybe a building is being brought down, or some vegetables are going to go to waste or rot, and so there'll be need to take immediate and instant action. And parties will be brought together very quickly, and within perhaps a week or 2, even a decision will be rendered. That's one type of case. Then there is the case, like a succession case, that involves wrangles that will go on for years, and you cannot complete them because the parties also, usually a respondent who is an unwilling respondent, he is reticent and does not want the matter to proceed.
Yes.
Notwithstanding the speed at which the judge wants to proceed. And I'm not saying that there are no other weaknesses. There are other weaknesses that, and I think we acknowledge that there are always weaknesses in the system. But this is, you've got to appreciate that there are different types of cases. Constitutional cases, petitions started by petition, do not go for the same form of a hearing that a normal civil case will go through, because there you have pleadings that go through a long process before the parties are ready to actually testify. In petitions, there's no.
But is it possible, regardless of the nature of the case, let's say a standard civil matter, can we ascribe a certain period within which ordinarily a matter should be dispensed with, so that we don't have this, even with unwilling or reticent respondents or parties? A court has determined that this matter has to end within this certain, period, beyond which it doesn't look reasonable. It's a waste on the court's time and the public's time. Is that possible to establish?
It is possible. I think we are working very, very closely with the Directorate of Performance Management now, of the Judiciary, and we have a system that will partly be disclosed during this conference. And I think, in fact, Prof is probably in a better position because he has a little more information. The JTI has been working with them on the performance management aspects. Perhaps, Prof, you might want to
and the other issues you wanted to
let me pick that up, because I think it's very important that we level with Kenyans about some of the challenges we face here. The problem of case backlog and case delay is a serious one. in the judiciary, and it still remains a serious one. Now, when the current Chief Justice assumed office, the number that was bandied about the backlog, and we define now backlog as any case that is more than 12 months, any case that has not been decided within 12 months, we classify it as backlog. We've done that deliberately because the international standards, and I'm talking about ISO standards, for civil cases is 18 months. But we're trying to be a little even more ambitious, and we are trying to use 12 months as a benchmark for trying to do this. Now, that number, through certain procedures, dismissing cases that were dormant for a long time and so forth, and physical count and audit of the files, the exact number of the case backlog that we now have is about 311,000. Okay. Now, if you look at 311,000 cases in the High Court, if we just concentrate on the case in the High Court, because that's where the problem is the biggest, we have 91,000 cases that are backlog. Okay, this is from a physical audit. Now, if you look at the last financial year, July to June, 54,000 new cases were filed. Okay. Now, out of the 54,000, 26,000 were disposed of. Okay, that puts the clearance rate of the High Court at just about half.
50%.
Just at about 50%. Now, remember, there is a backlog of 91,000. So even assuming that no new cases are filed, if you look at the clearance rate at 26,000, it will take at least 3.5 years.
Yes.
To finish the backlog, right?
Yeah.
But 54,000 new cases,
keep
keep coming, and we see that number increasing. It has increased in the last 3 years out of confidence that people have in the judiciary. We don't begrudge that. But the flip side of it is we're seeing a lot more cases coming to the High Court. So which then means that we must widen this conversation beyond the judiciary. We must ask the question whether, in fact, the High Court can sustain 54,000 cases a year. Okay, that's a question that we must have, because even if you keep increasing the number of judges, then we have to say there is something else that must give.
We must go to witch doctors and others.
Right.
and priests and, and arbitrators.
Yes. Here, there is an important statistics that we, comparative statistics that we must be aware of. If you look at a country like the United States, on average, at the federal court, on average, a judge completes about 504 cases, at least from the statistics of last year. That's how much one judge disposes of. Out of which, the 504, the settlement out of court. So a case was filed, the complaint was filed, it went through the motions and so forth, but the judge never had to hear witness number one. 92%. 92% are settled, you never have to hear, you never have to write a judgment. You take that, the case of Kenya. It is the flip side, it's the exact opposite.
Yeah.
Okay, so a judge in Kenya, if you use the 26,000 cases and look at the number of High Court, and by High Court I mean all the courts of that status, so the industrial and land and environment, you'll get that on average each judge was disposed about 325 cases in a year. But out of which, how many were settled out of court? About 8%. Okay? So then you can see, then we have a problem, right? Yeah. So we have a problem that is that goes to our legal culture. We have a problem that our lawyers are not settling cases that perhaps they should settle. But I want to make it clear that it's also a vicious cycle. In as long as we have the case of backlog, and people know that it will take 3 years to complete the cases, they will not be in a hurry to settle. But if we get to clear the backlog, so it's a case of an emergency. It's a national emergency of some sort. It's toxic.
But let's move up below, which is not the mandate of the superior courts. The magisterial courts down there. There's also quite a huge clog up of cases, and in fact, there is where they take longer to get determined. From your perspective as a judicial training and transformative initiative, how are you approaching that, the lower cadre?
Two things. First of all, statistics say otherwise.
Really?
If you look at the number of cases, I think we have about 124,000 cases backlog. But if you compare the number of magistrates we have 461 magistrates in Kenya. Okay?
Yes.
So compared to 91,000 in the High Court and only 90 judges, 461 judges and a backlog
Yeah.
of 124, it tells us that it will be much easier to deal with the case of backlog in the magistrates' courts. However, it's important to say that the numbers of the magistrates in the last 3 years have increased by 54 and by 109, and the year before by 29. So we've almost doubled
Yes.
the magistracy level in the last 3-4 years. So we expect a lot of changes coming forward. However, one of the challenges we have is there are some cases that yes are taking very long in the magistrates courts, and that's because most of the magistrates were still fairly junior, so they don't have particular jurisdictions. Because they were hired very recently. And that's one of the reasons that the Judicial Service Commission is moving with speed to promote some of the judges that have reached, that have the experience.
But I guess
that
it's
is
also
required to
which
do
type
that.
of cases. I mean, I think the
Yes.
family division cases, the ones that take longer to adjudicate, if I may hazard a guess. And in the children's court and so forth, a lot of matters are staying there for very long before they're resolved.
Right.
Yeah.
Well,
One of the problems we have with the family cases is the law. You know that there's a provision that that places the ceiling of the cases which can be heard in the magistrates' courts at 100,000, and we've always asked that that should be increased so that they can hear. I mean, a chief magistrate will be able to hear a normal civil case of 8 million, up to 8 million shillings. So we are saying, instead of limiting it to 100,000 and then the rest go to the High Court, why not increase their jurisdiction with regard to the succession cases to something in the region of 5 million? And then we don't have to have matters delaying or moving up to the High Court.
Yes.
A few weeks ago, a newspaper published articles, a series of articles about the judiciary, and they were very depressing. You see some kitchen, which is also a registry, and you see the structures, the infrastructure is horrible. What about that? Is that part of your discussion?
yes, it is of course part of the discussion. As you're aware, the Judiciary Transformation Framework has 10 key result areas. And it's a transformation framework, it's not even a strategic plan, because we absolutely have to deal with the very fundamental issues. We have to deal with issues of not having toilets. We have to issue with problems of not having registries, even though it's a court that's supposed to have registries. We are talking about problems of there being no enough furniture, so people who work in the registry have to sit in turns. You know, you sit between 8 and 10:30, and someone else between 10:30 and 12, and so forth. So those are very, very basic.
Why is that so? Because the judiciary makes a lot of money.
Well, the judiciary, yes, the judiciary does raise revenue, but remember, the revenue doesn't come to the judiciary.
I know it goes to treasury.
It goes to treasury. However, I think these are problems that are being addressed fairly quickly. Again, I think it's very. There have been a lot of changes. For example, there have been a lot of refurbishments that have happened in the last 2 years. In the nature of news, we don't focus on those success stories. It's true that there are places that still very urgently require attention. The new Chief Registrar has put that as her priority, and the Judicial Service Commission has concurred with her. So this financial year, what they're going to be focusing on is really providing spaces for the registry, providing basic amenities in all the courts. We're talking about, restrooms. We're talking about,
reception areas.
Reception areas and so forth. So that hopefully in a year, we will not see that kind of story again.
In your operations as members of the bench, we have a lot of many schools, many universities training lawyers.
Yes.
Who are appearing before you. And some of them went to the School of Law. Some, I understand, some files get lost there. But are you happy with the outcome?
Graduates.
The lawyers who are appearing before you?
Principal Judge, you must answer that question.
Yes. at a very high risk. Let us just say that we acknowledge that the situation in the country with regard to professions churning out members of their profession.
I'm not happy with journalists myself.
That there has been a problem.
Yeah.
That there is a weakness. We see it in the pleadings. When pleadings come in, you can immediately see that there's a problem. Even you have difficulties deciphering sometimes what the lawyer is saying. So yes, we acknowledge that there are problems. I think that is an issue that the School of Law and the Council for Legal Education, of which you are a member, on our behalf. He's one of the members of the Council for Legal Education. But these are some of the problems that the Kenya School of Law should be addressing. I think they have made some steps in that direction, because the term of training now is a bit stricter and it's longer. And the requirement for internship has also, I think, increased. So I think the students who go to the Kenya School of Law now are taking about 2 years before they are out in courts.
Can I respond very quickly to that?
Yeah.
Let me say, first of all, the complaints about the quality of lawyers that are coming into the profession is not limited to Kenya. Just before taking up my appointment, I was a professor of law at the University of Washington in Seattle. And we heard this again and again. But this time, of course, the complaints were being addressed to the universities. You're not doing a good job in producing lawyers who can think critically. You're not doing a good job in producing lawyers that are ready for the market and so forth. We've seen that problem in Kenya as well. Now, sitting at the Council for Legal Education, this is something that we are trying to grapple with. The first step has been to bifurcate the role of the Kenya School of Law as a provider of postgraduate education, and the Council for Legal Education as a regulator of both the Kenya School of Law and the universities. And we are really focusing on the standards of accreditation, for example. And we're becoming very, very strict at the Council for Legal Education to make sure that, first of all, right from admission to the quality of teachers and professors that a school has and so forth, to the kind of exams that are given, this is taken into account. Because I believe, however good a job the Kenya School of Law does as a postgraduate training institute, if the lawyers that are coming in have spent 4 years regurgitating notes rather than actually going through a period of rigorous training,
yes,
it's not going to help.
Which raises the issue. I mean, in America, of course, law, the discipline, the profession of law requires people to get in at a certain level.
After first degree.
As graduate program. Yes. Seeing how bad the lawyers coming before you are. And also boiling down to what, in fact, the Chief just spoke about that yesterday, that in fact, there are also questions being raised about the quality of judges. Looks like the pool from which lawyers are coming and judges are coming, which is the same, has a problem. Shouldn't that be addressed in a global way by saying we lift the admissions or the training of lawyers to be a postgraduate enterprise?
As a personal opinion, I have always thought that law should be studied here as a second degree, because then it gives people time to mature in a first area of exposure or a first profession. And then you take law only when you are satisfied for yourself that this is really the area which you would like to focus on. So personally, I would go for that. I think you will find great resistance from Kenyans and from particularly the Law Society of Kenya, because it just means that it takes a little longer
to become a lawyer.
But I think there's a question of more...
And it's not just even with the law. I mean, I hold the same view for journalism. I think that journalists need to take that degree after first degree, that you have a certain foundation grounding to be able to perform.
But what I would agree is about thinking about it from a global perspective. I think that's a good idea. But I would have pause before we come to too quickly to that conclusion. I'm speaking here as a son of a peasant from Loitoktok. And I'm concerned about access.
Yes.
I think it's a serious issue. We're already seeing a lot of, I already have a lot of angst about access to the profession because the Kenya School of Law's fees are already very, very high. And a lot of people who've somehow are bright enough to go to public university get help from HELB have gone through the university are being unable to enter the profession because they cannot afford the fees that are charged at the Kenya School of Law, and help has not been extended to cover the postgraduate institutions as yet. So I think it's something that I think we can consider, but I think we'll have to think very seriously about our financing mechanisms for university education generally. And once we've addressed that, and we can make sure that issues of access, so that children from poor families have as much access to the professions as those from able family, then I think we'll be ready to have that discussion. But at this point, I think before we've touched the financing mechanisms, it might have
be prohibitive.
Yeah.
But what about the claim that even there are not enough good people to sit on the bench from the lawyers fraternity? That in fact there is a shortage of judge material in this country, and the CJ was even proposing we might resort to going back to getting the Dugdales we used to have in the 90s.
Well, I take your bias by saying we'll get Dugdales and not Scofields. No, I do think yes, there's a serious challenge. But remember, our constitution. Being a judge is one of the state offices that's left open for non-citizens as well. But I don't think the Chief Justice was necessarily saying that all the lawyers out there are not fit to become judges. I think one of the things that he was saying is that a lot of lawyers that are doing very well and making a lot of money in this town are not ready to take public service. Because being a judge is a public service. There are a lot of people who are judges who could be doing much better in the profession. They could be doing much better in other areas and so forth. So you make a choice to serve your country. You make your choice to join public service and work as a judge. And you give up
are there lawyers who are appointed, who are doing very well, they appointed judges, they decline? Does that happen?
No, because now we have a system of
I remember one who was appointed, the former chairman of the rugby union, Omoela, was appointed by Fiat and it declined. He said, I'm quite happy where I am.
He probably felt that he was earning
much better, more comfortably.
And it's not just, he's not alone. I think there have been two others. There was Nancy Onginde and I think one other person who have been appointed and declined. Now,
let's just talk about what you do, because all these people come out. Some of them, as we are saying, obviously they were in private practice. They're not perhaps judge material. Isn't it the job of the Judicial Training Institute to make them, to train them to be judges and good ones?
Absolutely. It is our job. It's one of our 3 mandates, perhaps the most important one, at the Training Institute, and we are trying to raise the institute to be able to do that as effectively as possible. As you are aware, we're doing all these reforms at the same time. It's easy to forget. So it's only 2.5 years into the reform efforts. We've made quite a number of changes. One of the things that I think I'm very proud to say is that I think, as I said at the beginning, all our judicial officers have embraced the spirit of learning and intellectual curiosity. So in fact, we don't have any challenge in terms of encouraging them to take up judicial education and learning and so forth. We've introduced some very rigorous induction programs and continuous judicial education. The Judicial Service Commission is about to hopefully adopt a policy where each judicial officer is not only entitled but is required to submit themselves to a minimum training hours per year across the board, just to ensure again that you're keeping them, they're keeping themselves abreast with the law, but not just the law. It's also about the judicial craft, which is really the most difficult thing to teach. You might be a very good lawyer, but shifting on the other side it becomes a little bit of a challenge.
Who teaches in your institution? Is there judges, or do you have permanent staff? Who is there?
Right now, we don't have permanent staff except support staff and myself and a few magistrates. I consider everyone who works in the judiciary as part of my faculty. So I always
So
say,
you don't have these tenured retirees, former judges with experience in writing judgments who are resident at
no, we don't, but that is actually where we are heading. At least for short terms, you could have juris in residence programs and so forth. This is some of the ambitious plans we have at the institute. But at now, we draw upon the more senior judges to come, and not just from Kenya, but from across the region. We draw upon people from outside the region as well.
And don't forget that even amongst the judges who are in situ, who are doing judgments on a day-to-day basis, there are people with specializations. Yes. So, for example, if one of the courses he is teaching is alternative dispute resolution, he will call upon me because I have expertise in that area. Yes. If it's procurement law, he will call another judge who has expertise in that area. If it's judgment writing, he will call on a judge who has retired to come and teach. And I think we have so far, we are happy that he has developed, the JTI has been able to develop a faculty that we feel fairly satisfied with. Okay. But of course, the longer term would be to actually appoint tenured.
So thank you, Judge. We apparently I invited, open a complaints division here. We have not attended to much. The conversations seem to be very deep. But they just, flip through some of the queries coming in, and they relate to the delays in cases being processed. Somebody said we've had a land matter which dates back up to 1979. Up to now, the case has never been concluded. He didn't give the particulars of the case. Oh, he did actually. Winam, senior resident magistrate's matter, and so forth. We'll probably forward these matters to you.
That would be very useful. Yes, very useful. Yes.
Yes.
Another one. I'm having an appeal case which filed in 2007. To date, nothing has been done. Thiongo, he gives his telephone number there. About a civil matter, Kakamega local, since 2006 up to now, the case is still dragging. My file has gone missing. Please advise, and so on. It is a lot of. All of them are cases that have not
moved as quickly as
an appeal was filed against a civil matter in 2003. It's been pending since 2006. File has gone missing. Evelyn in Vihiga, and so on. And a law student says perhaps in the proceedings of today's and this week's conference annual meeting ought to be available for them to have access. I'm sure you have an internal way of processing. But there are quite a number of things which we will ask that they be sent to you. Some of them require actually administrative intervention,
right.
The way I see it.
Yes.
Yeah. But maybe just to conclude our conversation, somebody has a succession case of 1982. It has never progressed. Those are really Kenyan suffering. But in conclusion, of course, the matter of the appointment of new judges. The list was passed on the president. He did a few. You said the others are still under consideration. What does the Judiciary Training Institute make of this? Does it mean the president is still vetting them before they come to you?
I think, Mr. Makali, you asked that question to the wrong person. Yeah. I think probably the principal judge is in a better position. It's much higher in the pecking order.
Yes.
What is your position on this?
Yes, when we went for the swearing in of the 11 that were appointed, we did actually have a meeting between the President, the Chief Justice, the President of the Court of Appeal, and myself. And there was a small discussion. It wasn't lengthy. But the President did express that his role is not a rubber stamp. That he considers that as a citizen who has a responsibility of governing the nation, he also must follow the Constitution. And that is that if he has information that causes him to doubt or to believe that there is a different view he should take on any matter that comes before him, he is obliged by his oath of office to dig deeper into that issue. So that is where the matter rested, and of course we could not insist that you must give us the 14 appointments in the next 1 week. Yes. So that is a matter that perhaps if you want to follow further, you would have to follow office of the president.
Or the Attorney General for that
And
matter.
or the Attorney General.
Yes.
Yes.
Okay. All right. I guess we will leave it there. I want to thank you for coming, Professor Justice Joel Ngugi from the Judiciary Training Institute and the Principal Judge of the High Court. But Judge, before I leave you, actually, what does the Principal Judge do? Does he preside over all the high courts, or what does it mean?
Very interesting question, because it's not defined very well in the Constitution, although it's a constitutional office. The principal judge is an elected office, elected by all the judges of the High Court, Environment and Land Court, and the Industrial Court. And this actually happened in my case in March of last year, so I'm just over 1 year in that office. The role of the principal judge is to consult with the Chief Justice and the Chief Registrar of the Judiciary to enable smooth administration of the courts. You must be aware that there are administrative aspects of the running of a court that must have a judicial input. And so a person like myself is the person who gives guidance in the administrative aspects, so that there is a smooth flow of things in those courts.
Okay. All right, that was our discussion this morning. The judiciary is meeting from this, what they call the superior judges are meeting from the High Court, the Court of Appeal, the Supreme Court, in their conference to look at what they're calling transformative justice under the new constitution, happening this week. And our guest this morning, we have questions, of course. You
Happening
can find
actually today.
And they're starting today, and we've held them a little longer than necessary. They're being presided over by Justice Professor Joel Ngugi. So we want to let them go, and thank you for coming. And keep
Thank you very
pushing.
much. Thank you very much.
Yeah.